Okay, welcome. My name is Doug Blizzard with Catapult. We're happy to have you here today around a topic that we get quite a few questions on in our advice team around PEOs and how they work and how do I get into one, how do I get out of one, things like that. So we're here today to talk about all things PEO. And happy to have Carrie Cherveny and Stephen Legrand from Hub here. Introductions coming in a few minutes to help us understand this somewhat confusing world. I will say, we're not here to promote or to bash them. We're just here to understand them better, to educate you. There was a time in our history where these things were not regulated, and yeah, there were some interesting situations that happened, including here in North Carolina, and we all know of one or two of them that went under, and but that's not the case anymore. So it's really more about understanding how they work and what you're getting yourself into should you be in one. So again, administrative wise, we have the typical things happening today. Everyone is muted. If you have a question, please type your question in the little question bar there, and we will try to get an answer. We will be recording this, so again, if you want to watch this later, if you have to drop off, you can see it later. So again, with that, I'm happy to be here. I've got my pen out to learn. I'm going to learn a lot too. So with that, Stephen, take it away.
Sure, thank you, Doug. Again, I'm Stephen Legrand. I'm with Hub International. I'm here in Raleigh today doing the webinar. I oversee all things Hub International in the Carolinas, and so we're happy to be here and partnering with Doug and with Catapult. I'd like to introduce Carrie Cherveny. If we were in person, I would probably ask for a show of hands of how many people on this webinar have attended a webinar in the past through Catapult that Carrie has done. Carrie's kind of pulled us through. Carrie, as I was thinking about it, we've done Paycheck Protection Program, remember that term? Vaccine mandate stuff. We described a new term that the insurance industry took on called furlough employees. Remember that from a year and a half ago? So a lot of you have attended a lot of the things we've done with Catapult and with Carrie's expertise through Answers at 8, Thinking Differently, and a whole host of things. So we are excited that you joined us today. I would like to take a second to go over a little bit of what we're going to try to accomplish, as Doug said, and then tee up why Carrie is the right person for you all to hear about this. So demystifying, I had to look it up. It means to make something easier to understand. So to Doug's point, that's really what today is about. We're simply here to try to make something easier to understand as it relates to the PEO world. PEO is a solution, it's not the solution, okay? And depending on your company and the life cycle that you're in and the culture you have, and a lot of circumstances will determine whether it's the right solution for you or not. And we're just here today, again, to demystify it, just to make it something easier to understand. Why Carrie is good at this. So there's 4 things I would say about Carrie. One, she's been in HR, so she's walked in all of your shoes before as a human resources professional, so she knows what you deal with. She then became a lawyer, we don't know why, and practiced employment law, was a defense attorney for employment law. She then became in-house counsel for a PEO. So she's actually worked inside of a PEO and has frankly as good an understanding of the PEO world as anyone I've ever met. So I think this will be a really good session for you guys today. And then most recently, Carrie has spent the last 6 years with us here at Hub, working with all of our clients and employers to help try to keep them out of trouble, I guess would be the best way to put that. So with that, Carrie, I'm going to turn it over to you and welcome and thank you for being a part of our program.
Well, thanks, Stephen. I think I have to mail you a friendship dues check or something. That was lovely. So good morning, everyone. I own nothing green, so I am not in the spirit of St. Patrick's Day today, but I am gonna have a green beer later, if that counts. So getting right to it, because God knows I'm really good at the rabbit holes. We have a lot to cover today. Really, today is about arming you with information. Doug said it very perfectly and appropriately. We are agnostic when it comes to PEO or no PEO. We're really here to teach, to educate, and to inform. When I was general counsel in a PEO and then thereafter at Hub, I've come across a lot of clients who don't necessarily understand the relationship that they've entered, a lot of the legal components of PEOs and PEO relationships, and just overall a lot of details and considerations and figuring out whether or not PEO is the right solution for you. In many cases it is, but sometimes it isn't. So hopefully when you're done with this webinar, you will walk away with some good information that will help you make some good decisions. All right, so we're gonna jump right in and talk about what a PEO means to you. What is a PEO? What is this acronym that we see thrown around an awful lot? Well, I'm going to give you a little quick history lesson. Yes, I can actually be quick and succinct at times. But a PEO was historically referred to as employee leasing. Way back in the day in like the 90s, early 2000, which cracks me up that that was way back in the day because that feels like yesterday to me, which means I'm getting old. But it was traditionally referred to as employee leasing. PEO stands for Preferred Employer Organization or Professional Employer Organization, but it is a co-employment relationship. Now, for many of you on the call, you are probably familiar with joint employment. Joint employment is what you have with, say, a staffing company. PEO is one step removed from joint employment. Co-employment means arm's length. They operate as your administrator, as your consultant, providing guidance, but they do not become involved in the day-to-day decision making, or at least that's how many PEOs build their model. What I want to say and preface for everything we talk about today is that not all PEOs are built the same. So I am talking in generalities. You may be working with a PEO today that operates differently, and you may say, Carrie, that's not how my PEO does it. That won't surprise me. There's a lot of variance in PEO models, so this is generalities today. And generally speaking, PEOs attempt to operate at an arm's length distance, providing some kind of liability shield between the PEO and the underlying client company. The good news for client companies are that they are ultimately the deciders of their employees' fate. And we're going to talk more about that in a few moments. I'm curious, before I get through to the other two bullets, how many of you all have worked with a PEO or are currently working with a PEO? So we're going to throw up our poll question for you. And we're wondering, have you worked with a PEO in the past? Yes or no? And meanwhile, just to give you guys a little context of my current situation, we adopted 2 kittens in December, and I'm sitting here watching them do everything that they're not allowed to do. And for some reason, they seem to know I'm not able to yell at them at the moment. So they are in all kinds of shenanigans on this St. Patrick's Day. So have you worked with a PEO in the past? The majority of the folks are saying no, but many certainly have. So we've got a lot of you familiar with PEOs because you've worked with them. And for many of you, this might be new information. So that's really great to know as I gauge my conversation with you today. So we've talked about what PEO means. It is a co-employment relationship, and PEO is different than staffing because your employees are actually sitting on the tax ID number of the PEO. So they are the employer of record. They are responsible for paying payroll taxes. And in most cases, they are responsible for providing the workers' compensation. And since they sit on the tax ID number of the PEO, you also have access to the PEO group health plan and ancillary products. I'm going to unpack all of those things as we talk through our program today. A couple of comments about the contract that you'll sign with the PEO. And while we're talking about PEOs, some of the lessons that I'm about to share with you about the contract are general good business practices when it comes to any contract, whether it's a payroll provider or a technology solution, whatever it might be. The contract will absolutely have insurance requirements. So be sure that if you enter into a relationship with a PEO, that you address those insurance requirements. They'll have general liability insurance requirements. They may require a bond of some sort. So pay attention to the insurance requirements. The PEO will likely also have a clause in the contract that requires all of your W-2 employees to be paid through the PEO. So if you have an entity that you're carving out and it's a commonly owned entity, you might inadvertently breach that contract. So be very careful about that all-inclusive language with respect to the employees that have to be paid through the PEO when you enter into that contract. There's also additional fees built into PEO and payroll contracts. So this is a lesson just for payroll contracts in general, whether it's PEO or a standalone solution. There's often additional fees for additional manual checks, manual check runs, supplemental runs, bonus runs, year-end W-2s, 1094s, 1095s, setup, implementation. So when you get a quote from any vendor for payroll, whether it's PEO or standalone, make sure you pay attention to any additional fees that might be built into that arrangement. Be careful of auto renewal contracts. And here's another contract life lesson. Anytime you enter into a contract, make sure you can get out of it before you get into it. How do you terminate the contract? How do you leave the relationship? How do you break up? Some PEOs auto renew, some PEOs and some contracts in general only give you a 30 or 60-day window to exit the relationship before the end of the contract. So my general life lesson for any contract is, how do you break up? And you got to know how to get out before you get in. That's really important. Some contracts might require a personal guarantee, so you want to look for that and then decide if you want to, if your CEO or CFO, whoever might be signing that personal guarantee, wants to sign a personal guarantee. And generally, there is a jury trial waiver and a no choice of forum, meaning the PEO is going to pick the court, the state, the jurisdiction where there might be litigation. Okay. Indemnity and liability shifting. All contracts that you sign, regardless of the vendor or partner, will have some kind of liability limiting language, indemnifications. Everybody who enters into a partnership or an arrangement wants to protect themselves from liability. In the PEO environment, you will find language that will shift liability for things like wage and hour, employee classification, discrimination, harassment, hostile work environment, litigation, causes of action, activity that may arise from the employment relationship will generally almost always be shifted to the employer. That helps support that co-employment arm's length relationship. I find probably 1 out of every 8 or 10 clients that I talk to that are in a PEO relationship or considering a PEO relationship misunderstand the nature of the relationship and believe that the PEO provides some amount of liability shifting to protect the employer from employee litigation, and that's just not the case. And that's okay as long as you go into it knowing that, generally speaking, in a co-employment relationship and based on the contract, the employer, the client, you guys on the phone, will likely carry the liability for employment-related litigation. Same with I-9, same with E-Verify, same with the Affordable Care Act. All of those legal obligations that you have to your employees, all the alphabet soup, right? That doesn't change because you're in a PEO, generally speaking.
The question then, Carrie, so given that they intentionally want to keep it at arm's length, do you see still, though, PEOs wanting to be involved in who you're going to hire or fire? Can you address that quickly?
Yeah, 100%. And I'm going to unpack that in great detail in the EPLI section. But Doug, it's such a good point because the PEOs are putting you on their tax ID number, right? And they're carrying the insurance for the business side, the EPLI. They're carrying the state unemployment tax rates. And so there is a financial liability to the PEO if they bring in a client company that's a bad actor and starts getting sued and has turnover and loses unemployment claims. There's a financial impact to the PEO. They have skin in the game too. So you will definitely find that PEOs want some level of involvement in your employee relations decisions for sure. Great question. All right, so let's talk about how PEOs generally make money in the client relationship. One of the things that we do here at Hub is unpack the financials associated with a PEO relationship, because any of you who are currently in a PEO or have been in a PEO know that many times, not always, but many times PEO will bulk bill you. So they will bundle up a number of different cost centers into one rate. And maybe you'll see your admin fee and a cost center called tax. And maybe the work comp will be inside that admin fee. So employers often come to us and say, well, if we're going to leave the PEO, we need to know that we're going to save money, and we can't figure out how if we're going to save money because everything's bundle billed. And oftentimes that's by design. Now, PEOs are increasingly moving away from this methodology, and I'll tell you, of the big five, and you guys probably can figure out who they are, 3 of them in the last couple of years have unbundled their bills, and there's transparency around the pricing. But PEOs make money in a number of different places, and this is why when we help a client leave a PEO, we back into their bundle billing, we know how it's built, and we unbundle it and identify the markups. So what do I mean by markups? Because you're probably thinking, well, I know I pay an admin fee. You do. But PEOs make money in other places too. So think about it this way. You're sitting on their tax ID number. There's a bunch of other clients sitting in that tax ID number. And so there's fees associated with that tax ID number that get allocated across all of the client companies inside of the tax ID. Those fees are marked up by the PEO, which represent revenue. More specifically, workers' compensation, for example. Workers' compensation is actually a fee, not a premium, because the premium's charged to the tax ID number PEO. They take that premium, allocate it across all of the companies in the tax ID number, and put a fee on top of it, which represents things like administration, claims adjudication, safety people that the PEO employ, but there's revenue built in there as well. Same with state unemployment taxes. And I'm gonna illustrate this in a subsequent slide and unpack it for you. Other places that PEOs make money besides admin fee, work comp, and SUTA fees, many times PEOs will bill you a % of gross payroll for your admin fee. And by the way, this is something to pay attention to for standalone payroll vendors as well. If you're being billed by a PEO in particular on the gross wages, that means that you're not getting that discount for the pre-tax deductions coming out of your plan, like pre-tax health, pre-tax 401k, pre-tax dental, because you're paying on gross. So you're losing the benefit of a pre-tax program. Now, PEOs that bill on a flat fee, it's more likely you're able to recoup the tax savings. As a side note for payroll companies, any vendor that bills you on gross wages or a % of wages gets a raise every time an employee gets a raise, gets a bonus every time an employee gets a bonus. So flat fees are really kind of the way to go when negotiating admin fees for both PEO and for payroll. Other places PEOs may make money, some PEOs mark up other kinds of products like posters, handbooks, helplines, whistleblower lines. So other products and services, the WOTC Targeted Jobs Tax Credit Program. So there's other places where PEOs may make money with respect to product. So just ask those questions, right? If you're gonna go into a PEO or if you're with a PEO today, now you have some of those talking points to ask those questions of the PEO. All right, moving on to payroll. Foundational point. The payroll services and technology services that you're getting from a PEO are essentially the same as payroll and technology that you get on a standalone basis. There's a lot of payroll companies out there, pay this, pay that, pay who, pay what. I don't want to name anybody in particular, but we know there's lots of payroll companies out there. There's lots of PEOs out there. The payroll technology, process the pay, process the taxes, process the overtime, cut the check, direct deposit, running reports, tax filings. The technology is essentially the same. The core difference between payroll and PEO and payroll and standalone, or what we call ASO, Administrative Services Only, is whose tax ID number is running the payroll. Is it the PEO where everybody sits inside the PEO tax ID, or is it on a standalone where it's your own tax ID number? When you come out of a PEO, so you guys will hear me say this several times, I'm a huge Stephen Covey fan. I think the highlight of COVID, just a little side story, the highlight of COVID for me, and this tells you what, that COVID didn't have a lot of highlights for me, was when Stephen Covey LinkedIn connected with me. I was like fanning out. I was such a fan. It was crazy. But begin with the end in mind. That's where I'm going with that story. So when you leave a PEO, you're generally not able to bring with you history, data, claims report, payroll history, unless you're running reports and dumping them into Excel or into CSV files. So as you think about getting into a PEO, remember that you're going to have limited ability to transfer or move data from the PEO into your new system, and you'll likely be doing it manually through CSV uploads and Excel spreadsheets. The new system setup is generally not difficult today. So if you're leaving a PEO and going into a standalone solution, or leaving a standalone solution and going into a PEO, you can usually move data through CSV uploads, but generally what you're moving is current state data, not necessarily historical data. So what does that mean? If you're going to make that transition to or from a PEO, pull your data, get your history, get your reports, and get it organized in your system so that data is meaningful and useful to you later on down the road if you ever have to look something up for your employee. Another side note, as we talk about data, I want to talk about EEO-1 filings. When you're in a standalone solution and you're 100 or more employees, you're responsible for filing an annual EEO-1. I know that Catapult is a huge resource in helping us figure out what we're supposed to do and how to do it. EEO-1 filings in a PEO operate differently. The data is consolidated as a multi-employer data filing. Now, the EEOC just issued new rules on PEO EEO-1 filings and said PEOs this year have to start separating out all the EEO-1s so each client company can get their EEO-1. That was dropped like out of the blue, out of the sky on PEOs, and they have to re-engineer all of their technology to be able to make that happen. So I just don't know how these poor PEOs are going to comply with it this year, but put that on your radar. If you're leaving PEO and you want your EEO-1 data, for example, next year you'll probably be able to get it, but this year is going to be a tall order for them.
Carrie.
Yes, sir.
We have a question along those lines. So we've got a member that used to be in a PEO, and now they got an IRS notice 3 years later saying they owe taxes for 1094C, 1095C filings. What do they do about it? Is that correct, normal?
Yes, so ACA is one of those obligations that remains with the employer, much like FMLA remains with the employer and not the PEO. The PEO can administer, you can outsource the work to the PEO, but you're not outsourcing the liability. So a couple of comments for those of you who have issues that arise post PEO, or for those of you in a PEO right now, this is a good lesson for you, or a good thing to think about for you. With respect to tax filings, 1094s, 1095s, and W-2s, the law, the regulation is that employers are responsible for obtaining, retaining, distributing, and filing those tax filings. Even if you outsource it to a third party, ultimately, the employer is responsible for that record keeping and record retention. 90% of our clients do not actually obtain and retain copies of their 1094s, 1095s, and W-2s because they have faith that their third-party vendor, whether it's a payroll company or a PEO, has copies of those documents in the event that they ever need them, and I totally get that. But when you break up with your vendor, breaking up is hard to do, and you don't have copies of your documents, the vendor may make it a bit challenging to get those documents from them. And what I mean by challenging is they're probably going to charge you a fee and then they'll release the documents to you. So if you don't have your documents, you've left a PEO, you've left a payroll provider, you've left a tax filer, reach out, see if you can get them. They may charge you a fee. The fees aren't exorbitant. It's not prohibitive. It won't prevent you from getting them, but just, I don't want you to be surprised if that's the approach they take. So if you have a penalty letter from the IRS, you definitely need your 1094s and 1095s to compare to the penalty letter itself to figure out what your appeal rights are going to be. Reach out to that vendor, get copies of the documents, you might pay a fee, and at the same time get an extension from the IRS on your appeal in response to the penalty letter. Does that help?
Carrie, I'm curious, because we all know how when you go buy anything in the payroll, PEO, HRS world, it's very confusing what you're getting, not getting. How is this kind of an area that the PEOs kind of gloss their way through, or they make it crystal clear? Employer, you still own these things. What's your experience there?
You know, it's such a great question. And unfortunately, my answer, I'm such a good lawyer, it depends. But legitimately, it does. Different PEOs and even different payroll providers have different levels of transparency and communication style, I guess might be the way I want to describe that. So some vendor partners and PEO partners are very transparent and very clear. And in fact, when I was general counsel, we had an entire addendum that we added to our contract that said our responsibilities, your responsibilities, and we had our clients sign it. I think a lot of PEOs are really moving in that direction. I think payroll providers are very good at that. I think ACA vendors in particular are super good at delineating between what they do and what the client does and who's responsible for what. And there's a number of vendors out there that just do ACA filings, for example. So it depends on who you're working with. I guess the best advice I can give is if you're reading a document and you're unclear, either get the document revised to make it clear or look at other vendors, because you don't want to sign something that might be vague or unclear.
Carrie, if I may, just to kind of put a bow on that for clarity from Doug's question, the PEO in that situation generally doesn't hold the liability for that IRS letter that you get back. The answer is not, well, I'll just send this to my PEO because it's their problem, right?
Correct, and here's why. The ACA in particular is comprised of two penalty components, right? We know and understand that. The A penalty and the B penalty. There's only one component of each of those penalties that connects back to the plan itself. The plan must be minimum essential coverage and it must be minimum value. Those are penalty components tied back to the plan itself. So long as the PEO is offering coverage and the employer has selected coverage that's minimum essential coverage and minimum value, the PEO is done, right? It's now up to the employer to be sure that at least 95% of the workforce has that offer of coverage and that their contribution structure is affordable and that the data that they put into the system corresponds to the actual offer and reflects a compliant offer of coverage. And guys, that's for a payroll system or a PEO system. Garbage in, garbage out. That phrase exists for a reason. The PEO is not responsible for ensuring that the contribution is affordable, for example. And by the way, this goes for FLSA too. The PEO is not responsible, nor is a payroll provider responsible for ensuring that you pay your employees in accordance with state, local, or federal minimum wage. The PEO and the payroll provider are not responsible for ensuring that your overtime is paid properly. This is why partnerships with companies like Catapult is so important, because these partners are not in the business of compliance, right? But you get that compliance consultation from Catapult, who can help you review your wage and hour rules, your wage and hour setup to be sure that your payroll is being processed appropriately. So does that help?
It does, and I wanted us to chase that a tangent on that for a minute, just because, as you know, Carrie, and many of the people on the call probably know, when the IRS has been slow to get cranked up on sending the letters, but now they are, right? So I think that in 2014, 15, 16, it was kind of crickets, but now you all will start to see that more and more. So I just wanted to bring that up.
Well, and let me explain the why behind that as well, Stephen, because I think if you have the context, it helps you be better prepared for what's coming. In COVID time, right, it's all blurry. I want to say spring of 2021, could have been 2020. The Inspector General's office, and the Inspector General is responsible for oversight of government agency operations to ensure that our taxpayer dollars are being used appropriately and that government agencies are running and operating the way they should be. So the Inspector General's office audited the Department of Labor, the Wage and Hour Division, OSHA, the IRS, and the ACA Enforcement Unit in particular in the IRS. And they were not happy with what they found in OSHA and in the IRS. I'm not going to go down the OSHA rabbit hole, but just to put that on your radar, they got hit hard too by the Inspector General's report. In particular, with respect to the IRS ACA unit, the Inspector General came in and said, you're not enforcing, you're not collecting penalties, you are way below our anticipated penalty collection amount. It must be because you're not engaged in rigorous enough enforcement activity. So the result of that is the elimination of good faith relief. Many of you have probably read our bulletins or heard about this. It means that the IRS is now enforcing penalties without accepting the whoopsies, right? Whoops, I made a mistake. Whoops, I didn't realize there were no 2 codes here. Whoops, I miscoded this. Whoops, I miscalculated. It really was 95%. That starts with your 2021 filings. Even before that, the IRS is actually recalculating affordability. So they are already engaging in enhanced rigor before we even get to the 2021 enforcement. They're at 2019 right now, and they've started asking for supporting documentation, which they never asked for before, and they're recalculating line 15 on the 1095C to prove up whether or not the plan is actually affordable in their eyes. Then they send a penalty letter with an X on the PTC listing, and the X means we recalculated and we don't think this is actually affordable. So we are seeing increased rigor from the 1094, 1095C process. So audit, audit, audit. Go back to 2020 and 2021 and check your filings and make sure that they're completed correctly, because it's a lot easier to do a refile, right, a corrected return, than it is to defend against the IRS at this point. So I know I just went down a rabbit hole, but these are great questions and I'm happy to deliver any information that's useful. Anything else on payroll in particular? Because I'm going to get into taxes and that's a whole nother can of worms. Okay. All right, taxes. So let's talk about the foundational concept associated with payroll taxes and being in a PEO relationship. As a client company of a PEO, I've said this before, you're sitting on their tax ID number. They get billed by the state and by the federal government. You have account numbers set up through the PEO so that you get credited for the tax payments made on your behalf. And then the PEO takes that big fat tax bill and allocates it across all of its client company entities. So when you leave a PEO mid-tax year, you may have a tax restart. In fact, you will have a tax restart at least for your SUTA. If you're coming out of what's called a certified PEO or a CPEO, then many of your federal taxes will not restart, but your state taxes will. So we recommend you leave at the beginning of a quarter or the beginning of the calendar year. I've got a lot of CFOs who've said, I'm saving so much money. I don't care about leaving mid-quarter. I can reconcile my 940s and my 941 tax filings. We're leaving mid-quarter. But we just want to put that on your radar so you can think about the timing of leaving a PEO if that's the direction you're going. And likewise, going into a PEO. If you go mid-quarter, then the PEO is going to take on the responsibility of the new taxes, but you're going to be left with a part quarter tax filing in the quarter that you leave. Also remember, if you leave mid-tax year, 2 W-2s, 2 1095Cs, because they're 2 tax ID numbers. When you come out of a PEO, if you've been in a PEO for more than 3 years, you're going to enter at the new business rate for SUTA. And you want to make sure that's a great opportunity for a lot of clients. A lot of clients are like, new business rate, that's way better than what I seem to have been paying in the PEO or even before I went into the PEO. So you want to be sure that whatever payroll provider you implement as the replacement solution, that payroll provider is really guarding your unemployment. Stay on top of your unemployment account, stay on top of your claims, work with your payroll provider to defend those unemployment claims. Any questions about that, guys? Okay. The last thing to consider on the back end of a PEO is if you're a multi-state employer, and from what I'm seeing, almost everyone has become a multi-state employer because people sort of picked up and moved during COVID. And I've had so many clients call and say, well, I currently have an employee in Hawaii. Oops, that wasn't our intent, but they moved. You're gonna have to set up state unemployment account numbers in each of the states where your employees reside and work. And those payroll replacement vendors out there, those technology solutions we're talking about, many of them through power of attorney can set up those account numbers for you, but that's part of your intake. So at Hub, we actually have a technology consultant. So when we have clients leaving a PEO, our technology consultant helps the client identify the replacement solution. And one of the things we look at in the replacement solution is, will they work under power of attorney and set up state unemployment account numbers? All right, HR, we got a lot to talk about here. Lots to consider. And here's I start every one of these slides with kind of like foundation considerations, right? So from an HR standpoint, when you're looking to leave the PEO, many of the HR obligations can be delayed to post implementation. For example, you probably are going to need a new handbook. You should not continue to ride on the PEO's handbook if that's what you've been doing, because the PEO's handbook references the PEO relationship and the PEO itself and PEO resources, like maybe the PEO whistleblower line or the PEO HR support team. So you're going to need a new handbook. That can happen in the first couple of months after exit, right? The whole process of leaving a PEO is about timing. At Hub, we actually build an entire schedule for our clients so that they know and understand who's responsible for what happens in each month, what that timing looks like. When Catapult's the HR partner, leaving the PEO is much easier because Catapult's going to fold right in and build that handbook, handle the FMLA, handle the management training, and they'll be part of our PEO exit strategy and our PEO exit project plan that we build for our clients. This is a proprietary tool that Hub has built just for PEO exits, and Catapult is hitched to our wagon and helps us do this for all of our shared clients. So a few things to think about. When you're leaving a PEO, you got to get copies of those I-9s if you haven't been doing them yourself already, because you've got to figure out who signed Section 2. In most cases, PEOs today want nothing to do with Section 2 of the I-9. They do not want to be the employer for I-9 purposes, and that's appropriate. There's nothing wrong with that, and it makes your life easier. If you're coming out of a PEO that signed Section 2 and put the PEO down as the employer, which again is pretty rare, you're gonna have to do all new I-9s. I-9 rules apply. So you can only do those I-9s in the first 3 days after the effective date leaving the PEO. You can't do them in advance. That's over documentation. Over documentation under I-9 rules are actually more serious than mistakenly completed. I was looking for the word. Incorrectly completed I-9s or missing documentation. So I-9 rules, you got to follow those to the letter of the law, literally. You're probably going to need new posters. You want to look at your policies, complaint procedures, your HR operations, and all of this is built into the project plan that we build with you, and Catapult helps support from the HR side. We talked about EEO1 before. Again, keep that in mind as you set up your new systems to be sure that you're capturing that EEO1 data, because you're going to be filing your own EEO1s if you have 100 or more employees. And then think about HR operations and processes. Thank goodness Catapult has so many great forms and policies and templates and custom documents that they can build for you, but you're going to need basics like discipline forms if you've been using the PEO, FMLA processes if you've been using the PEO. The other thing to think about is if the PEO has been managing your FMLA for you, you got to get your hands on those files, the certificates of healthcare providers, the return to work releases, the request for the FMLA, the designation form, because remember, at the end of the day, the DOL is knocking on your door, not the PEO's door. You outsource the work, not the liability. So if you ever have an FMLA audit from the DOL, they're going to need the records that support FMLAs from the last 3 to 5 years. So if that's sitting with the PEO, get that stuff. Same with ADA, payroll records, time and attendance reports, all of that data, anything you can get your hands on in advance, download that and hold on to it. And we've already talked about tax forms. So you certainly have to get your hands on tax forms as well. Any questions about the HR side of the house? All right, work comp and employment practices liability insurance. I'm going to talk about work comp and FLSA sort of together because there's some similar concepts here. When you take on your own system or process, or when you move into a PEO, you want to be sure that your employees are classified correctly. We've already talked about the fact that that liability remains yours, right? We've already talked about the DOL knocking on your door, not the PEO's door. So when a PEO advises on how to classify your employees, or when you're taking your people out of a PEO, you've got to assess whether or not your work comp job classifications are appropriate for the job. And at Hub, we help you do that if you're a Hub client. And you have to assess whether or not your employee classification under the FLSA is likewise the same. And the reason I lump this discussion under the work comp discussion is because oftentimes, from a technology standpoint, your setup will connect your work comp code and your FLSA code. So 8810 may automatically set or default to non-exempt. For example, 8810 is your clerical workers' compensation code. So you've got to audit both sides, either going in or coming out, to be sure that you've got your employees set up correctly. I will tell you that from an FLSA standpoint, the Department of Labor just hired 1,000 new investigators last month to specifically investigate employee misclassification, both misclassification as an independent contractor and misclassification for wage and hour purposes. Again, I don't mean to shamelessly plug Catapult, but their HR people are the right people to help you figure out if your employees are classified correctly from an FLSA standpoint. From a work comp standpoint, if you're a client of Hub, we have experts who help with that. The risk of misclassifying a worker from a work comp standpoint is that the carrier can come in and say, oh, no, you've had them misclassified. You haven't been paying the right premiums. You didn't set us up to assess the risk entirely or accurately or appropriately. We're denying this claim. So the ramifications of misclassification are big. This is not the place to cut corners. Yes, an 8810 clerical code under work comp can save you money until Murphy's Law comes to life and you've got an 8810 work comp claim that's big dollars and the carrier comes in and starts doing a little digging and says, no, 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 this doesn't work. When you're in a PEO relationship, your work comp is usually set up as what we call pay as you go, meaning you're paying for the workers' compensation on an ongoing basis. There's no year-end annual audit or true up. And that model used to exist only in PEO. Well, carriers have figured out that clients really enjoy, especially CFOs who write budgets and try to manage the budgets, really enjoy not having that year-end, very painful work comp audit where they either write a check or wait some period of time to get a credit back because they ended up in the positive, meaning they overpaid in premiums for the year. So carriers actually will allow standalone client companies to be on a pay-go or pay-as-you-go model. Again, Hub as a broker is very adept at that. When you come out of a PEO, be prepared that you will not have loss runs. Carriers know how to deal with this. Experienced work comp brokers like Hub know how to deal with placing coverage without loss runs. But if you can run an injury or accident report, that would be helpful. Some PEO systems allow you to do it, some don't. Again, employee job descriptions, huge issue. Definitely work with people at Catapult to make sure your job descriptions are written properly. And listen, it's not just work comp and FLSA, right? One of you guys has got to be thinking, Carrie, why haven't you mentioned ADA? I'm so glad you asked. I can ask my own questions in my head, so many voices. ADA is a core component of your job description. As you're making decisions about accommodations and workplace safety, you need to identify and delineate in that job description essential job functions, any physical requirements, intellectual requirements, all of that should be mapped out. And I know the folks at Catapult can help you build ADA compliant job descriptions that will also support your classification for FLSA, for work comp, and even ACA. Are they full-time? Are they variable hour? You can mush all of that into a really well-written job description. Also, when it comes to work comp, you will now have the ability to determine your own return to work policies and processes. You will also have the ability to build out your transitional duty or light duty programs. I have a lot of companies say to me, well, Carrie, we don't do light duty. Well, do you do accommodations under the ADA? Well, of course we do accommodations under the ADA, then you do light duty, right? Light duty essentially is not discretionary. ADA has a lot to say with the accommodations you need to make to bring people back to work. Again, Catapult really well positioned to help you blend your transition work, return to work, light duty programs with ADA obligations. So any questions about work comp? Okay. EPLI. So a lot of people don't really know what EPLI insurance is and misunderstand it. Employment Practices Liability Insurance. This is the insurance that responds to discrimination, harassment, sometimes wage and hour, ADA, FMLA, all the employee relations alphabet soup. That's the insurance that protects the business. That is not directors and officers insurance. Directors and officers insurance protect the directors and officers. EPLI protects the business, and oftentimes if an individual is named, if the law allows an individual to be held individually liable or responsible like the Fair Labor Standards Act does, then EPLI may protect that individual. In a PEO, you are provided with EPLI insurance. The insurance provided by the PEO is more limited than what you will get on your own. And it makes sense, right? You've got the insurance carrier, the PEO, and then the employer. So the carrier is 2 steps removed away from the employer and the employer's practices. So they're going to protect and guard their risk pool, and their policy by having more narrow coverage. Oftentimes, EPLI is also has a higher deductible. So a lot of times clients will say to me, well, Carrie, if I have less coverage, if it's more narrow, if I don't get FLSA, for example, in the PEO's EPLI, I'll just go out and get my own EPLI. The risk with that is the carrier's doing this. And what that means is carrier number 1 in the PEO is going to say, wait a minute, they have their own policy. They should pay first. Well, your own policy will also say, wait a minute, you're in a PEO, you have insurance through the PEO. They should pay first, and they do this number. And I've had clients who have actually had to pay 2 deductibles. So if you're going into a PEO and you want to take advantage of your own EPLI, ask the PEO if they will carve out your coverage under the PEO's EPLI. That way you can have a more rich, robust EPLI plan on your own. If EPLI is a challenge for you, if you've had bad claims history or issues, then take advantage of the PEO, because I always say something is better than nothing. If you're leaving the PEO, you need to pay attention to those post-contract termination considerations. PEOs don't like clients to leave EPLI claims behind. So you still have ongoing obligations to actively engage in a defense. There's still hammer clauses, which may cut off coverage if you don't accept a reasonable settlement. And there may be penalties and fines built into the contract that can apply post-contract if you don't do the things you're supposed to do to help wrap up those left behind claims. So make sure that you're paying attention, and then work with a broker if you're leaving the PEO to build out an appropriate EPLI. You might need wage and hour defense if you have a big non-exempt population. You might need third-party coverage. You might need NLRB coverage if you've got a union population. So definitely work with an EPLI broker like Hub, of course. I'm going to plug our company too, who can help you work through those plan design considerations. All right, we are getting close to the end. I'm going to go through employee benefits and then talk about some timing considerations. But any questions before I move to a whole new subject? Are we good? All right, employee benefits. Guys, this is really my favorite conversation and my favorite topic. So sitting inside of a PEO and taking advantage of the PEO master employee benefits means that, I'm sorry, I thought somebody was saying something. Okay, means that you will always be inside of a fully insured program. Let me explain what I mean by that. PEOs are, and I don't want to get too in the weeds, but PEOs are what's called a multiple employer welfare arrangement. There's lots of unrelated companies sitting on that tax ID number, sitting inside of that health plan. And because you've got lots of unrelated companies sitting inside of this health plan, federal law and state law in particular discourages and in many states prohibits, flat out prohibits, self-insured PEO master plans. So you're always in a fully insured environment. And for some companies that works perfectly. But for companies that are growing, that are looking to be more creative, more strategic, that want to start doing carve outs and bringing in different kinds of vendors for the health insurance and different kinds of programs and products, that are interested in getting money back at the end of the year if they're performing well, sitting in a PEO fully insured wash, rinse, and repeat each year may not be the right solution for you. It's a great solution for smaller groups, right? Community rated, age band rated, that can get really expensive. And so sitting in a PEO master plan with, hundreds of other people could be a great solution. So things for you to consider as you weigh, do I belong in a PEO? Do I not belong in a PEO? What does my future look like? Am I in M&A activity? Am I in growth mode? Am I gonna be 50 or 100 employees in the next year or two? In that case, you might want to consider other options versus a fully insured PEO master plan. Some PEOs will let you be in the PEO relationship and go out and get your own benefits. Some PEOs will not. So another question for you to ask the PEO. When you're in a PEO master plan, you are limited to the PEO programs, the PEO carriers, and the PEO plan options. If you don't like United and United is the master plan carrier, you may not have any other choice but to be with United unless the PEO lets you go out on your own or unless the PEO contracts with a number of carriers. You will not, just like the work comp, have access to claims data or claims report, and it's difficult to pull a census. So again, if you're going into a PEO, begin with the end in mind. If you're going to leave in a year or 3 years or 5 years, you're going to have a hard time pulling a census and you won't have any claims data to come back out of the PEO. So if the PEO is the right solution, maybe the health plan isn't, and maybe you want to keep that separate so that you can retain your claims data, so you can retain access to your census. The PEO is the plan sponsor, so they're responsible for compliance. Really check this, right? Make sure you're getting those SPDs, make sure you're getting those plan documents. If you're not, Hub Chief Compliance Officers like myself and Hub Employee Benefit Brokers can help you on the plan compliance side. So drop us a note, we're happy to answer some questions. Most PEOs are doing the ACA filings. Stephen already asked such a good question. I feel like we covered this in detail, but if you have more questions, we're happy to answer them post-webinar. But benefits is a big consideration, and there's a lot of ramifications associated with going into a PEO master health plan. So be sure to think about that. Also get examples of how they're going to communicate with your employees. What benefit administration support will they provide? Are they going to do billing reconciliation, COBRA? Are you going to get compliance reports for COBRA? These are all things that third-party vendors can do outside of the PEO for you as well. So these are things to explore in and out of the PEO. At Hub, we like to build a 3 to 5 year strategic plan for a group coming out of a PEO. What I say to clients all the time is if you're leaving a PEO, year one is going to be bumpy. I am not going to lie. We do everything we can to escort you through that process. We project manage the entire process with you and for you as partners. It's a collaboration team effort with you, but it's still bumpy. It's a big transition, but 3 years, 5 years down the road, you will be in a position to make bigger, more robust decisions for the business because you have been on a standalone basis. What are the solutions available to you leaving the PEO? At Hub, we provide technology consultants, communication and design marketing team, compliance for benefit plans, and in partnership with Catapult HR compliance and consulting, helping you build your HR infrastructure, your SOPs, your forms, your documents, your toolkits, your policies, your processes, all of those fun things. I think that stuff's really fun, by the way, so I'm a little geeky that way. Are you interested in creative wellness initiatives? Do you want diabetes management programs, for example, or weight loss management programs, consultants who can help with all of these plan performance controls, absence management? We've already talked about Catapult being able to help with FMLA. Hub has an entire absence management team for presenteeism and workforce management. So lots of strategies available as you come out of PEO, just making sure you pick partners who can help you with those.
So Carrie, one question was asked quickly. So as far as your health insurance, how it's set when you're in a PEO, there's no more age banding, no more. I mean, how does that work? How do your premiums get determined then?
So the PEO is going to rate you along with everybody else on that master plan. They're going to ultimately have access to your claims data, even though you can't get your claims data. The PEO has all the claims data sitting inside of that master plan because the carrier's got to underwrite the group in its entirety. That's the benefit of being in a PEO, is that you're pooling your risk, or the downside, depending on who you're pooling with. You're pooling your risk with lots of other companies and lots of other plan participants. So the PEO and the carrier will underwrite your group based on the risk information they're able to get on your way in and the risk and claims data that they continue to have access to as you sit inside of the PEO. And then they rate you as large group. Make sense?
And we are literally at time. I hate to cut you off, but we're at time.
No, that's okay. This is the end of the program as well. Timing's everything. It's perfect.
Wow, I just want to say thank you to Carrie and Steve in particular, but Carrie, great job. This is a topic that is mysterious, partly because of the variability, partly because of you get the bundled rates and whatnot, but still it's something that it's hard to answer sometimes. And just as a reminder to all of our members, this is one reason how we can help you, either ourselves or with partnerships like with Hub. So thank you so much for your time today and your expertise. And wow, what a topic. There's so many layers to this topic. It's interesting. So thank you so much.
Well, thanks for having me, everybody. As always, it's always a pleasure to present to the Catapult membership, and happy to help. Happy St. Patrick's Day.
So a couple of last minute things for us here before we hop off. Again, this is part of our ongoing series to educate our members on healthcare topics. As you know, Catapult is now in the healthcare business. We are a co-owner of Hero Health Plan, so we're trying to bring you objective third-party education and products here in this world. So please, if you have questions, reach out to us. A couple of things coming up, and not mine. We've got a next week on the 22nd. We do have a session around a Hero Health Plan. If you want to learn more about that, come register in that. We have a small business healthcare summit coming up in April 13th. So come hear from a lot of experts in the small business world. There actually are more solutions in that world than you might be aware of. A lot of people think that if you're small, the only solution is pay a lot of money or join a PEO. There are more solutions, so join us there. And then finally, in mid-May, May 19th, we're having our big employment labor law. We're so excited to bring this back. This was an institution at CAI in Raleigh and for 30 years, and of course COVID kind of killed that for a couple of years. So we're happy to be back in person. There will be a virtual option as well, May 19th, May 20th. So again, with that, again, we're right at time now. Thank you so much, Carrie, Stephen, for all you all do at Hub and on this topic specifically. So hope you all have a good day, good St. Patrick's Day. Go pinch someone that's not wearing green in a non-harassing way, of course. So have a great rest of the day, and we'll see you later. Goodbye.
Thank you, Doug.